Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for 4 different cases. The first one is State of Iowa versus Matthew James Myscheid. That case is submitted without oral argument. The next case and our first oral argument for the day is State versus Hawkins. And it looks like the parties are ready. Ms. Reddy, you may begin.
May it please the court, counsel. Mr. Hawkins appeals his bench trial convictions for 3 counts of assault with intent to commit sex abuse. He first urges that while there was specific intent from which a fact finder could find, while there was sufficient evidence from which a fact finder could find the requisite specific intent to force a sex act with regard to the first victim in the first incident, there was not evidence to support that same sort of finding with regard to the second and third incidents. In particular, what's missing as to those second and third incidents is any indication that he desired to go, or he had a specific intent to go beyond what actually happened, which was a brief touching of the buttock of each victim. Whereas, the conduct with regard to the count 1 incident was ongoing and continued until it was interrupted by an external force, namely the arrival of third parties on the scene. That circumstance did not exist with regards to count 2 and 3.
Time transpired between the first victim, MB, and the third victim, EM.
It's not clear exactly how long, but it does appear it's a very short time, maybe within, I would say, no more than 15 minutes for sure.
That the first one crossed that line. And so within a few minutes in the elevator with EM, you're saying that there was no step towards accomplishing a sex act when he put his fingers from her thigh to the small of her back?
Touched her buttock, going from the thigh to the small of her back, correct.
And that, with respect to that incident, doesn't the executive director of this food bank place, didn't she testify that the defendant was also holding his crotch when he was doing that and saying, "Help me"? That sounds like that would, fill in any gaps on intent evidence that the state might need.
Testifies that happens after the touching of the buttock. It's not simultaneous, but more important, both the victim on that count and that director, the observer, testify that he had a sad and scared look on his face at the time he's saying, "Help me," and touching his crotch. And that is another factor in which that incident is directly distinguishable from count 1, where the victim in count 1 says that he seemed to be sexually aroused and was engaging in this sexual contact.
There wasn't somebody there immediately to stop, like there was in the elevator, right? The director saw it happening.
Change in circumstance that existed at the time he engaged in the conduct, and therefore if he intended to continue the conduct, that there was no change in circumstance that cut off that intent. The other important point to remember is that the specific intent to commit a sex act has to occur at the time of each individual touching and has to be specific to each individual victim.
In isolation, or can you consider the evidence of victim number 1 in evaluating his intent on 2 and 3?
Consider all of the conduct, certainly, but that doesn't mean that it gives rise to an inference that intent for count 1 continued to count 2 and 3. Typically, we do not infer that intent to commit a sex act against one individual means that the defendant also has intent to commit a sex act against separate individuals. The exception to that is in the modus operandi type cases, like in the Cassidy case that the Court of Appeals cites. But the important question in that circumstance is whether the course of conduct is so unique and starkly similar that they appear to qualify as modus operandi, kind of unique courses of conduct that he engages in.
That his intent in the first assault is completely legally irrelevant to determining his intent in the second and third?
I think the ability to find intent in count one would support a conclusion that if he engages in similar courses of conduct, maybe he's doing that with the same intent he had previously, but we don't have that here.
Right?
If there are similar courses of conduct, I don't think.
Similar conduct, the first assault occurring within a minute or a couple minutes has no legal bearing on what his intent might be on the second assault. That's what you're saying?
There's a general sexual intention, perhaps, but that doesn't mean that there is a specific intent to go beyond what actually happened to engage in one of the very specific types of touching that qualify as a sex act.
A district court's findings. So the standard of review is we have to construe the evidence in the light most favorable to the findings in the verdict. So I think to conclude that there's insufficient evidence, we would have to say that the inference the district court made here was wholly unreasonable, illogical, impermissible as a matter of law. And is that what you're saying?
That's correct. I agree that that a fact finder can make reasonable inferences. The crucial point is that they have to be reasonable inferences. Ernst tells us that. And in a circumstance where where you have separate victims and separate incidents and conduct, our position is that you cannot infer that he had a specific intent to commit a forcible sex act against the second individual and to commit a forcible sex act against the third individual because he previously had a specific intent to commit a forcible sex act against the first individual. And the reason for that is because the circumstances are different. They are not, typically we can infer that if an individual is engaging in an ongoing course of conduct and is interrupted, say a third person walks in, say the victim escapes his grasp, we can reasonably infer in that circumstance that his conduct would have continued, the progression would have continued and culminated in the actual commission of a sex act. But we don't have that with regard to count 2 and 3. We have that with count 1, certainly, but we don't.
Conduct in count 1 that violated the statute.
So the defendant in count 1 grasped the victim in count 1, engaged in humping behavior. She could feel an erection, and he then tried to engage in further touching and tried to put his hand down her pants. And
Touched her hairline.
yes, correct.
Thing.
Sure, for count 1, yes.
Hand down her pants, is that necessary for that to have qualified, or would it have qualified without him putting his hand down her pants?
I think possibly it would have qualified even without that. What's crucial is that continuing conduct and the progression towards a sex act, even if he hadn't done the touching at the hairline. But again, we don't have anything.
The statute only criminalizes assault with the intent to commit a further act. There doesn't actually have to be a substantial step toward the further act. So if he proclaimed, this is my intent, while he slapped someone on the butt, that would be sufficient evidence. Okay.
He doesn't, right? He doesn't proclaim that's his intent. We're missing any conduct or.
That was his intent, but for the presence of other people. In the stairwell with CC, and then Miss Yoder coming into the elevator with respect to EM. I think that was the district court's finding.
Into the elevator before the sex act. And saying that he would have intended to commit a sex act under different circumstances does not qualify to say he had a specific intent to commit a sex act at the time of this particular touching. The change in circumstance, or the circumstance that the judge relies on, is cutting off his intent. The presence of third persons, that was present at the time, before the touching and at the time of the touching. And that is one reason that the count 2 and 3 incidents are meaningfully different from count 1.
A bad plan rather than he didn't have the intent. I mean, that seems like given his state at the time, like I know you make an issue about whether he was, competent, he could form specific intent, but assuming he could, maybe that was his plan and it was interrupted by Miss Yoder putting her arm through the door and coming onto the elevator, and he acted it out, and I think she says, stop it, right?
No indication that it's, number one, there's no indication that that interrupts his behavior, that that's why he stops it. It seems to be after he's done with the behavior. But number two, even if she doesn't, we know that an individual cannot touch a virtual stranger's behind, even if she does not give a prior disclaimer not to touch her, right? So there's no change in circumstance there. And the intent that's necessary has to be the specific intent to commit a forcible sex act. So the idea that it's against her will, that she doesn't want it to happen, is inherent in it. And so what is the change in circumstance that we say resulted in him, not being able to complete the act he intended? Under that circumstance, the idea that, well, maybe he intended and it was a bad plan is overly speculative and does not support a finding of sufficient evidence.
Miranda violated. Could you give us your pitch on that?
So defendant does argue that Miranda was violated. I would start with the state's comparison of the incident to Terry or investigative stops. And what I would note is that with Terry and investigative stops, or traffic stops, what you have is either enforcement of a completed traffic violation or investigation of an ongoing criminal violation for which you have reasonable suspicion but not probable cause. The suspicion that criminal activity is afoot. In this case, you have a completed criminal action. You have allegations and accusations that the action was committed. And so what possible purpose is there for further investigation other than the discovery of evidence? This was not a Terry-type circumstance.
Kind of rewatched the video again yesterday and tell them if my summary's right. Basically, there's two officers. The police station is right across the street or something from this food bank, and so one of them comes over and starts to question him, tells him, "You wait. You wait." Actually, the officer testified he's not free to leave, and then leaves him with the other cop, and then goes and conducts an investigation. That doesn't sound like a Terry stop to me. That sounds like, you're not free to leave while we investigate this situation, an overall situation.
The officer acknowledges that from the commencement of that interaction, the defendant is not free to leave, and there's engaging in questioning and things. Before he then leaves the defendant with that second officer and goes downstairs. And so really what they're doing is investigating an allegation of a completed crime in order to obtain evidence bearing on that. I mean, we know that police officers investigate all the time after there's even an arrest, right? That continues. And in this case...
And what statement should be suppressed?
The defendant's position is all of his statements during the interaction with the police officer should be suppressed. And the state tries, at trial, the state argues that those statements, the denial of wrongdoing, evidences a guilty conscience and is itself an indication of guilt, substantive guilt, and of the requisite specific intent for count 1 and of the ability, for counts 2 and 3, and of the ability to form specific intent for all 3 counts in light of the diminished capacity defense.
This was tried to the district court. We actually have findings and an understanding of how the district court came to its decision. Is there anything in the district court's findings on the record that indicates the judge relied on the defendant's statements made during this custodial interrogation from your point of view? Because as I read his findings, he's just talking about the witness testimony and that's it.
He does not specifically reference the statements from the custodial interrogation. Of course, there were very brief findings. They were only, orally on the record, and that was certainly the basis that the state argued that was important, and we can't say that wouldn't affect a reasonable fact finder's conclusions.
If there was a Miranda violation?
For that very reason, that the state relied on his statements from the interrogation in arguing that he had a guilty conscience, and that he therefore had the specific intent and the capacity to form that specific intent.
maybe you think you've said it, but I want to make sure I have it right. In your blue brief on page 58, you said Hawkins was subjected to custodial interrogation without the benefit of Miranda warnings. His statements must be suppressed. Which statements?
I mean, all of his statements to the officer, that whole interaction should be, that video was introduced into evidence, right? So all of that whole interaction, but in particular, his denials of wrongdoing that the state hinges, that they say indicates his knowledge, his guilty conscience, and specific ability to form specific intent.
Better argument there, and this is, I'm going to ask the state about this, is at trial, there was a big effort to put on a defense that he's psychotic, he has mental health issues, and he didn't really appreciate and understand what he's doing. You watch that video, he seems to understand what he's talking about or know what he's talking about. That seems to me the harm that the video does, and the court does make a specific finding that he's not accepting the sort of defense that he lacks specific intent because of a psychotic condition. Am I missing something there?
That's correct. Judge, I do see I'm out of time. May I briefly respond? I do think that's correct. Even though, although defendant's position is that video does not undermine his diminished capacity defense, the state argued it does. The state's expert relied on his, on that as part of it, and the judge relied on it as part of it. So I agree that is another reason that it is not harmless. Thank you.
May it please the court, counsel. This court should affirm the defendant's 3 convictions because the state offered specific intent, sufficient evidence of a specific intent, and because there was no Miranda violation. Beginning with the sufficiency of the evidence, this court routinely views the evidence in the light most favorable to the state and takes all the inferences in favor of the verdict, and it uses the circumstances around a crime to determine if the state proves sufficient intent. The model instruction 200.2 tells juries that we use the circumstances around crimes to determine intent because you usually can't prove intent by direct evidence. This was a bench trial, so there were no model instructions, but that's the law in Iowa. State v. Cassidy is an excellent example of this point where the only evidence of the defendant's intent wasn't even the circumstances of the assault from that day, it was from years earlier, similar assaults.
Here's where I have an issue. I'm not troubled by 2 of the cases. I think it's MD and EM. But CC, as I understand the facts, they're just crossing paths on the stairs after the original incident involving MD, where everyone, I think, concedes there's sufficient evidence with respect to that. They're crossing paths on the stairs. As they're crossing paths, he just slaps her on the butt, is what CC's testimony is. And to continue on, the trial judge's finding, if we're going to focus on the trial judge's finding, is if there hadn't been other people around, that things would have escalated. He was attempting to assault these 2 women, including CC, hoping to commit a sex act against their will, which would be sexual abuse. Where's the evidence of that with respect specifically?
So
His intent was to sexually abuse CC.
yeah, the state's not here today saying if all you do is slap someone's butt and that's the only thing that happens, that's sufficient evidence. But here we have minutes before the defendant refuses a request to go ahead of EM. Then he uses a ruse by saying that she has something on her bottom to hit her bottom. He grabs her around the waist. He completes sexual abuse, although he wasn't charged with it because he touches her pubic hairline. And then with an erection, he thrusts into her bottom.
With CC, did he need to touch her at all?
Yes, because otherwise he didn't commit it. Well, if he had come sufficiently close through his conduct to, where someone would reasonably fear imminent, contact, yes. You have to get there. But if he's just standing in the stairwell, no.
Her back.
I think that's probably a fact question for the jury. But I will say that this court doesn't have to decide it because the buttock is right next to the anus, which is a thing that if you touch with your hand is a sexual abuse.
As I understand it, he slapped it and they're not sure if it was with an open hand or with even a forehand. Is that right?
If it was forward or backward makes any difference, but I guess I can't. I always conceived it of his palm, but I guess I don't know that they specifically said that. I don't think it matters because, again, minutes earlier he had an erection and thrust his erection into the bottom of a different person. She's still with that person and walks by and he hits her in the bottom and then he goes on to commit another sexual abuse that no one's an assault with the intent to commit sexual abuse that no one's really seems to be disputing the evidence is sufficient for.
Something different. Let's assume for discussion, I call them victims 1, 2, and 3. Let's say we throw out 2, the one we're talking about, and it's just 1 and 3, and it goes back for resentencing on the concurrent consecutive thing. Do you think that the judge would only talk about concurrent consecutive, or should they start over since there's kind of a change?
The victim 2, you'd still have an assault. It just wouldn't be assault with intent to commit sex abuse. So you still have 3 convictions. But I think if you reverse any of the convictions, you probably need a plenary resentencing. If you affirm all 3 sentencing convictions, then we can go back to just have a resentencing on the consecutive concurrent determination. Is that your question, Your Honor? Or am I?
Assault only and the sex intent to commit sexual act is removed. You're saying that would be a brand new sentencing because it's different?
If not, I think you would just remand for resentencing on consecutive deterrent concurrent if you affirm all 3, notwithstanding Duffield, because the parties agree that that is what should happen. But you shouldn't reverse the second conviction because, again, we have very close in time 2 assaults that no one disputes, not no one, but the court seems to accept the sufficiency of the evidence. The defendant had an erection minutes beforehand. He started every assault the same way by groping the buttocks of the victim. And in every instance of victim...
From the fact that he didn't touch the male that was present in the staircase along with CC, and he focused his attention only on the females that were present.
The court could use to infer the specific intent to commit sexual abuse with a specific type of victim in this case. And again, this court defers to the fact finder and gives the reasonable inferences to the verdict. This court in State v. Mathis pointed out the error in State v. Smith by the Court of Appeals was not sufficiently deferring to the reasonable inferences a fact finder could draw and crediting a competing, potentially reasonable inference that the defendant wanted to be drawn from the facts, and that the defendant's inference might be reasonable, that he only had a general sexual purpose. That's not the law in Iowa. The law is we defer to the fact finder in their resolution of reasonable inferences. And here it's reasonable to infer that when you have an erection and press it against someone and minutes later smack someone else on the bottom and start your assault in the same way, that person resists by saying you can't do that and leaves. That's sufficient evidence to infer that you had specific intent. That he wasn't especially resolute in carrying out that intent doesn't mean he didn't commit the crime.
To follow up on your comment about Duffield, so you're saying that whenever parties on appeal just sort of agree that it ought to be consecutive, concurrent, it should be the limitation of the judge's discretion on resentencing that binds us?
It should defer to the party's requests. Duffield spoke of it as a presumption of a plenary resentencing, not that the law demands it. And I think when the parties both agree that a carceral sentence was appropriate, indeed the defendant asked to be sentenced to jail a shorter period before the district court, I think that it's appropriate to solely remand for the consecutive concurrent determination by the district court. Had one of the parties resisted that, then I think that Duffield would apply and you would go back for a plenary resentencing.
The Terry stop issue, please.
For Terry, or Miranda violation, you need custody and interrogation. A Terry stop is, by definition, non-custodial. And you never are allowed to leave a Terry stop. That's the whole point, is you cannot leave. This stop was very brief. It was, the officer comes up with another volunteer from the soup kitchen. That volunteer has the guy come out from behind the door, and the defendant asks him to sit down, or the officer, or tells him to sit on the bench, and he does so, and then they ask questions. It's a public place. It's a church. There's other people around. The officer is polite. He asks for the defendant's side of the story. The defendant was on the scene. They didn't summon him there. The officer didn't confront him with evidence of guilt. He just said, this is what I've been told. What's your side of the story? He didn't push back. He just asked for him to explain. And while the defendant was not allowed to leave, we know that's not custody under the law. And he wasn't physically restrained. He wasn't held at gunpoint. He wasn't in handcuffs. So if this court used the factored test, the factors support finding non-custody. The state believes that you don't need the factored test because a Terry stop is, by definition, non-custodial, and this is a Terry stop. It's no more invasive than a pulling over a car, making the driver get out and complete standard field sobriety tests, and that is a Terry interaction. That's not custody under Miranda. And so, for those reasons, we don't think you need to apply any totality circumstances or factored test, but if you do, the law supports finding no custody. The second part of the interaction, the state doesn't dispute custody when the officer places him under arrest, but there's no interrogation. The officers asked 2 questions. They were, do you have anything illegal on you? That is a routine booking or arrest question. It's for the defendant's benefit so he doesn't commit a felony by introducing contraband into a jail. And then the other question was in response to the defendant saying no one called you, and one of the officers said, well, how do you think we got here? And it's a rhetorical question that's clearly saying someone did call us. And so that's not reasonably likely to lead to an incriminating response.
Collection of what Terry, the original Terry case was, is it was somebody sort of walking down the street and the officers were behaving suspicious. The officers had some suspicion of illegal activity. So they stopped the person just momentarily to question him. That's not really what happened here. I mean, he was told, sit down, and then asked a series of confrontational questions, and then told, wait here, and with the other officer, and then they go back, and officer number 1 goes and gets more facts, and then comes back. And during that whole time, he's not free to leave. That seems way, way, way beyond a Terry stop.
I disagree, Your Honor. I think pulling over a car and having the driver get out because you suspect them of committing a moving violation and then potentially being intoxicated, forcing them to do field sobriety tests, that is non-custodial under Miranda, and that is a much greater invasion on someone's freedom of movement.
And sort of stopping the individual are 2 different categories. It's sort of an apples and oranges kind of thing.
To DeCanini-Hernandez, which is a Court of Appeals decision. I appreciate it's not binding on you, but there an officer responds to a report of shots fired. There's 2 people there. He holds them at gunpoint with their hands on the hood of the car to do a pat down to see if they have anything on them. That was held to be non-custodial. And then he talks to them for, 15 or 20 minutes discussing if they were shooting guns and the report, and that was held to be non-custodial as well. There's no limitation on the movement. I think that it's fairly routine that officers will discuss with someone for a few minutes, and the first interaction was 3 or 4 minutes. It was very brief. That he sat there for another 7 or 8, no questions were asked. Then the officer's body cam from that part of the interaction wasn't admitted at trial. So you have 3 or 4 minutes of talking to a person in public, in a well-lit church, other people are around. I don't agree that he was really, reading him the riot act. I thought it was fairly conversational questions. I think that's what the district court found in its ruling on the suppression issue. And so I just...
Indicator, though, aren't cops kind of known for sometimes, I've heard of them pulling them over and saying, you don't mind if I look in your car, do you? Just because they're being nice about it, that doesn't mean it isn't questioning.
The court has considered as a totality of the circumstances. It uses a 4-factored analysis. The U.S. Supreme Court, I think, uses more of a totality of the circumstances analysis, but the nature of the questioning does go to whether or not a person's freedom of movement is curtailed in such a way that it's, analogous to an arrest.
Sit down, and the officer testified, and he was not allowed to leave.
You're never allowed to leave in a Terry stop. We know that that doesn't create custody. If it did, every Terry stop would be custody under Miranda, and that's not the law. In fact, the United States Supreme Court has held that you can be in jail and have people come talk to you, and it's non-custodial interrogation for the purposes of Miranda under some circumstances, because being limited of your freedom of movement is not a sufficient condition for custody for the purposes of Miranda. And so here, we have a very brief interaction with pleasant, I think, as far as it goes, quite pleasant questioning. The officer was nice. He invited the defendant to tell his side of the story, and the defendant just denied, which is totally his right. And then the officer went, talked to the victims, and placed the defendant under arrest. This is, to me, it's a quintessential Terry stop. And I think that the case is supported. If you compare this to State v. Park, I think that was a far more invasive situation. The defendant's freedom of movement was limited much more substantially. It was a much more serious situation. The actions were completed. The test isn't whether the crime's completed or not. The officers are allowed to go dispel or confirm their reasonable suspicion and then make an arrest or not, as the case may be. And so I think when you compare this to cases that have been found not custodial, State v. Park is another great example. I think this is far less analogous to a restriction on movement, analogous to an arrest.
I mean, I wrote Park, and I think she was free to leave, as I recall.
Free to leave. But again, that is not determinative, or every Terry stop would be custody under Miranda. And we know that that's not the case. And so because, in any event, if this court disagrees, because the district court's findings did not use any of the statements by the defendant in finding the defendant guilty, we know that it was harmless error. Sure.
I'd ask you there is, I mean, a big issue in the case was sort of a defense that was put on at trial was that this guy was having mental health issues. He was psychotic. He didn't have, couldn't form an intent to commit sexual abuse. And it seems to me the video is pretty darn damaging to that particular defense. Would you agree?
Yes, I can't say, it didn't impact the verdict from the perspective of reading what the court said. And I do think that both parties used the video by having their expert watch it. The defendant didn't object to that, and both experts testified about their views on the video, and the state offered dueling experts with the defendant's dueling expert, and they necessarily, that should be affirmed on appeal, at least from a sufficiency perspective. I would also add that there's no dispute about the facts at all that I can tell. Everybody agrees about what the facts are. The question is the conclusions to be drawn from those facts. And so when you have a verdict in which that's not mentioned, there's no basis for this court to conclude, well, I think it's really damaging. It should defer to the fact finder, especially when you have experts talking about why they think he has a diminished responsibility or not. And I see my time has expired. If I could briefly conclude, Your Honor. And so because of that standard of review and the verdict that was specifically rendered here, this court should find any Miranda violation harmless. And so for those reasons, Your Honor, we would ask that this court affirm the defendant's 3 convictions and remand solely for a resentencing on the consecutive concurrent determination. Thank you.
Ms. Reddy, when you get there, would you start right off with the concurrent consecutive aspect of sentencing? What is your recommendation?
I do think under the Duffield decision, which came down after the Court of Appeals decision in this case, it does appear that a plenary resentencing would be required, just based on the language of that. Turning first to the sufficiency issue, it's true that we defer to the fact finder, but it's also true that you have to look at all of the evidence and not just the evidence supporting the guilt. And the inferences drawn must be reasonable, not just feasible. And in this case, we know we can't make the same sort of inferences against a mentally ill defendant or a person who's exhibiting bizarre conduct or bizarre thought processes as you can, again, when you're dealing with, a reasonable, typical person, right? And we know in this case that with count 3 in particular, the individuals, the witnesses that testified, both the victim and the observer, Ms. Menger and Ms. Yoder, both testified that in connection with that interaction, he did not seem sexually aroused. Rather, he seemed sad and scared, right? And so that testimony in and of itself suggests that the count 3 incident was not based on a sexual intent, but rather based on, this whatever bizarre thought process was going on, leading to, a fearful interaction.
Agree that in looking at all the evidence for a sufficiency test, we can consider what he did to victims 1 and 2, as well as 3, consider all the evidence, right?
Has to be specific to at the time of the touching of each victim and has to be specific to that victim. So what does the fact that he had a specific intent with count 1, with the count 1 victim tell us when he has a touching with count 3 during which he is fearful and sad and doesn't seem sexually motivated. I mean, and grabbing his crotch, but again, that is at the same time as these help me statements in a quiet and scared voice with a scared, look on his face. The victim on count 3 says she wasn't scared, she just found it bizarre. It seemed like he, just had lost control in some way, is how she puts it. So the description of the count 3 incident itself is not sexual in nature, the way that count 1 is based on the victim's testimony in that case. So I think in that circumstance, you can infer intent for separate victims based on a separate conduct from the fact that he had a specific intent with a prior victim.
Miranda issue, the state says that free to leave, whether or not the defendant is free to leave, cannot be the one and only factor to consider. Otherwise, you have a whole host of police interactions that would become custodial interrogations for Miranda purposes. What is your response to that?
I think what controls is the 4-factor test. And of course, under that test, the free to leave piece is not the only piece. Defendant would certainly acknowledge that. And the other circumstances support that too. He's confronted with evidence of his guilt. He's, actively questioned, to tell.
Distinguish that from a roadside detention, which to me seems more intrusive. You're pulling somebody over. They're not free to leave. They can be ordered out of the car. We've said exit orders are constitutional. They answer questions. Why is this more custodial than that?
Terry stops are to investigate criminal activity that may be afoot, where there's reasonable suspicion, not yet probable cause, right? And so you don't have a defendant or the
Probable cause stop. You see a completed traffic violation as a police officer and you pull somebody over. You have as good a probable cause in that circumstance as you do in this circumstance. Why is this custodial and a traffic detention is not?
I'm not sure that Miranda applies to traffic violations. I do think you have to have, right? Okay, sure. Well, that's an ongoing offense, right? And the officer, is gathering information about an action that is afoot, the criminal activity that they reasonably, suspect may be afoot. We simply don't have that here. We have the officer, after having him sit down, confront him with, these people are making these allegations, right? And we already know they have those allegations. We already know that he's gonna, this is gonna result in charges regardless of what he says. So under that circumstance, there's nothing to be gained from an investigative perspective.
The fact of custody, which is a determination about control over the defendant, be contingent at all on whether or not the crime is completed? I don't understand the connection.
Part on the coercive effect. Oh, I'm sorry. I do see I'm out of time. May I conclude? The coercive impact, the coercive effect that comes into play that is part of Miranda considerations. Once the state has focused in on an individual defendant and is going to prosecute him, right? The coercive impact is much greater, and that does impact the custody evaluation. And so I think. But again, it is a 4-factor test that applies, and under that test is what establishes custody in this case.
Versus Hawkins is hereby submitted. And we'll have a pause here while the attorneys get ready for the next case, which is State versus Kepner.